Hi, my name is Jay, and this is part 2 of a series looking at the will template offered on financesdoneright.com. I would highly recommend, if you haven't seen it, check out part 1, especially if you're actually going in and filling out this will template. But again, it is financesdoneright.com, the website that is associated with this YouTube channel. You can find it under the tools section, and you can fill out print off a do-it-yourself will for yourself. So we're going to jump right in at distributions, and so this is looking at the section where you're actually allocating your estate out to your beneficiaries. Again, you have to, in the beneficiary section of the last episode, you have to list all the individuals who are going to be a beneficiary of your will, and then they actually appear down here. So each person that you list in your beneficiary section will have their own individual little section where you can then allocate an amount out to the individual. All allocations are done on a percentage basis, and this is just to ensure that you don't over-allocate. So let's say that if it was done just on a dollar amount and you gave John Smith $10,000 and Greg another $10,000, but you only had $15,000 in your estate. That complicates things a lot, and it's very dangerous. And also, if you make your will, say when you're 25, and then when you're 30, your wealth went from $50,000 to $200,000, but you only allocated $50,000, it just complicates things. And so it's a lot easier to do a percentage basis. You can only allocate up to 100%, which makes sense. And so you do that in this box. And for each individual person, you essentially set out how much you want of your estate to get allocated to those individual people. Again, keeping in mind, this is the estate outside of the specific assets that we looked at before. Any assets that you want to pass through before distributions will not count towards this. So if you're giving 10% to everyone equally, but you gave somebody individual assets in the section before, you might want to factor that into your decision making. So there's some key points here that you might want to look at when you're actually going through. It is important to note that you really should never try and do a revenge from the grave kind of thing when it comes to distributions. It's a very common thing where it's more common with dollar amounts where someone might say, oh, I'm going to leave this person $1 as a way of kind of giving them a finger from the grave. And it is a terrible idea. It is one of the most common reasons that wills are disputed and issues arise in court. It is a terrible idea to try and do anything that comes from revenge from the grave. You're not around to contest it. You can make a nightmare for your other beneficiaries when you try and do that. So just be respectful. If you don't want to give someone money, just don't give it to them. Don't give them anything. Don't involve them in the process. It's a lot simpler than trying to do things along those lines. It's also important to remember that jointly held assets are going to pass to the other individual listed on that, and it's going to bypass the estate. So that might affect your decisions. Keep that in mind. The final request area is a great way if you want to do things like, who do you want to take care of your pets when you pass away? Do you have any last words that you want to give to your family members? Any advice? Anything like that? That's where you want to put this here. Don't do any asset allocation in final request. Don't do anything like that. Specific areas for that. This is just for, who do you want to take care of pets? Who just anything that you want to put there is sort of last words to the individual beneficiary there. The next section we're going to look at is guardianship. So this is really important if you have kids or if you plan on having kids in the future. You can have this set up so that you don't necessarily have to remake your will when you do actually have children if you don't have any already. And it's really important if you do have children, you 100% have to fill out this section. If you're not sure about guardians, again, there's an information section that you can always look over at the side and we'll have a little bit more information about that. And guardians are the individuals who are going to be looking after your children when you pass away. They're going to be the people that are ensuring that they have education. They're going to be living with them and taking care of them until they are of age. So it's incredibly important that you choose responsible individuals who probably care about you and definitely care about your children. So friends, family, people along those lines. And as with executors, it is incredibly important that you talk with these people before actually putting them down so that they are okay and they know that they're going to have this responsibility if something happens to you. A trust is money that is held for any beneficiaries who are minors at distribution. So if you leave, say, $10,000 or 10% to a 10-year-old child, that money will be held in a trust until they become of age, when then it can be distributed based on a variety of different ways. This just ensures that when someone is young and potentially more irresponsible, they're less likely to spend all that money or lose all that money in various different fashions. And so you select trust managers who are going to manage that money and ensure that it is invested properly and distributed properly when the person comes of age. Again, incredibly important you choose someone who is financially responsible. and having a backup is always a good idea. Just in case the first individual is not around or not available, you have somebody else there who can fill in and take up that responsibility. And the actual structure of the trust is something you can choose as well. There are 3 default trust structures here. If you want to do something different, more unique, you will have to go through an estate lawyer. There are 3 provided here that are fairly encompassing for all the options you can do, and the wording is very specific so that there's no ambiguity, and that's why there are only 3 options and why you can't really do a lot of customization there, because it does leave yourself open to issues when you do that. And so different ways on it can be held until they become of age. It can then be distributed all right away on a percentage basis for a number of years. There's a couple of different options here to help you out with that. And you can read through those when you're making that decision and choose whichever one you feel is best. The next section is going to be your funeral request. This is where you're going to outline any requests you have for your funeral, any choices along those lines. So selecting between cremation and burial, pretty important. These are types of services and specific things you might want to have associated with your funeral. So if you want to make a wake, a memorial, things along those lines, you can choose whichever one you want. If you have specific religious mourning events that you want, this just gives information to your family about the kind of things that you want to have happen when you pass away, so that they're more informed and know what they should be doing, or giving them sort of better guidelines on what you might have wanted. Funeral service. So obituary requests and grave marker inscriptions, these, again, you don't actually have to fill these in at all, and especially with the last one as well. If you don't have anything in mind that you want, you do not need to fill them in. You can leave them blank, and the sections will not show up in your will. They're purely here if you are an individual who does have something specific in mind that they want with these. Same thing with additional requests. If you have something like, do you want your ashes spread in a specific place? Do you have any specific things that you want? This is a section where you can put it in. If you don't have anything, you can leave it blank. It just won't show up, and that's perfectly fine. These things aren't super necessary if you don't have anything in mind already. Do you have someone you want to officiate your ceremony? Again, this is typically more in line with religious events. If you have, say, a pastor or somebody who you specifically want, just put them down here, have that information. And if you have a prepaid funeral, this is really important. Prepaid funeral is where you actually go to a funeral home and you essentially prepay your funeral. You put the money up in advance so that everything is covered when the time comes. This isn't a necessary something you have to do, but a lot of people do it just to simplify the process when you do pass away. And it's really important to put down the information so that your family or whoever is taking care of your estate and funeral knows what's up. And so that's pretty important. And the last section is what we're going to look at is the miscellaneous section, and this covers various different things when it comes to, so a really important thing that a lot of people don't actually know is when you do pass away, your debts actually do pass away into your estate as well, and you can actually choose to forgive them or forgive a partial amount of them, or you can have them actually passed into your estate and they will be distributed to people based on that, and then they will have the right to collect that as well. And so fully forgive it. Name of the person, full legal name is a good idea, just so people know who it is. And then a residual clause ensures that if there are any assets in the estate, they are distributed. So what a residual clause is let's say you have 10 beneficiaries, and for whatever reason, some of those beneficiaries are not around to receive their amount. This residual clause will catch that money and it will be distributed to somebody. And so it is basically a catch for if there's nobody around to receive an item or an amount that you have specified. Now, with residual clauses, what is very common is something where you'll do, say, my children equally. And what that means is it will be distributed equally, any residual amounts between your children. You can also do this just to an individual person, like a spouse or anybody else. And a second residual clause is there just in case the first individual is not around to receive it. And that's a situation where you can have it distributed to, typically most people will do a charity, because that's an event where all of your beneficiaries aren't around to receive the money and your first residual clause is not available. It's a very rare case, almost never happens, but by having a second residual clause, it just adds a little bit more security to your will, and that's always a good thing. And so these are the various sections for your do-it-yourself will. It's fairly comprehensive when it does come to a do-it-yourself will. It covers a lot of areas, but if there are any sections you feel are left out for your estate, again, you're going to have to go through an estate lawyer. It's going to cost you some money. It's an unfortunate reality, but you need to go through an estate lawyer if you feel there are sections that have been left out in the sections covered in this and the previous video. It is a template, it doesn't necessarily encompass unique or out of the ordinary situations. So keep that in mind when filling this out and when completing it. And always keep in mind that a do-it-yourself will is always going to be less secure than a will made through an estate lawyer. So always keep that in mind. And the next video, what we're going to do is actually look at the printout of the will itself and discuss some of the terminology and clauses in there and what they mean. And also some of the requirements you're going to need to do when signing and witnessing the will.